Hey there, it's Jordan. Delighted to be joined by Nick Estes. You are a citizen of the Lower Brule Sioux tribe, also a journalist, historian, host the Red Nation podcast, and author of Our History is the Future, Standing Rock versus the Dakota Access Pipeline, and the Long Tradition of Indigenous Resistance, which I have now finished the book. It's really, really informative and a good read. So definitely people should check that out. Wanted to have you on. It's kind of been a avalanche of horrible Supreme Court decisions, and the one affecting Indian country has not, shockingly, gotten the same attention as others. But the Supreme Court recently basically reversed a 2019 decision that had ruled in favor of indigenous sovereignty, and they ruled essentially in favor of Oklahoma as a state, its rights to prosecute on indigenous land. Can you kind of break it down for people? What did they reverse? Because this is a reversal of a decision from 2019 that was favorable to Native Americans.
Sure. Yeah. So the case that was recently decided last week, Oklahoma v. Castro Huerta, was a case about a man who was actually not a citizen of the United States. He was charged and convicted and sentenced of child neglect, and he was through state courts, and he was basically put into or sentenced to 35 years in prison with the possibility of parole. This was all happening during what was called the McGirt decision, which you just referenced, and that was the decision that essentially found that 40%, well, actually it began with the Creek Nation or the Muskogee Nation reservation, basically found that that reservation had not been disestablished, and that the state of Oklahoma, although it was assuming criminal jurisdiction over that territory, had no power to do so, had no legal authority to do so. And so what happened with that decision, it kind of triggered some other lower court decisions that basically established, the entire or 40% of Oklahoma, which includes almost the entire eastern half of Oklahoma, as Indian reservation land for the purposes of criminal jurisdiction. It's important to point that out. So this case with Castro Huerta, he was charged with neglect of his child, who is a citizen of the Cherokee Nation. That was kicked out of state court. His sentence was vacated, and then he was retried in a federal court, and then sentenced to. Please try again. Sorry, let me turn this off. I don't know why this is on. He was sentenced to 7 years, so he got a lesser of a sentence, and I'm not really sure why that is the case. I didn't really look at his lower case thing, but nonetheless, the state of Oklahoma has been filing these cases to the Supreme Court in an act of desperation, and basically making the argument that the court system, the federal court system, the tribal court system within the state of Oklahoma is being overwhelmed because thousands of cases that would normally go through state court are now being put through tribal courts as well as federal courts, and the system simply can't handle it. That's the narrative that the state of Oklahoma has put forward. They created a very savvy and successful social media and public relations campaign. They've fabricated, for all intents and purposes, they've created numbers that we haven't been able to verify. I spoke with the Cherokee journalist, Rebecca Nagel, recently on our podcast, and she did an investigation on the numbers of court cases that were being transferred from state court to federal and tribal courts, as well as the numbers that the state was citing in terms of the people who were having their convictions vacated. They were saying thousands, and in fact, she could only find maybe a dozen and a half where that was the case. Others were being retried. Some of them still remained in prison. So this whole idea that there was, quote unquote, chaos, and I think Brett Kavanaugh actually used the word dystopia in writing the majority opinion of the court in describing this legal quagmire that was created, and also emphasizing that millions of people lived within these newly re-recognized reservation lands that were not native and were being basically, in the eyes of the court as well as in the eyes of the state, unfairly subjected to tribal as well as federal jurisdiction when it came to criminal court or criminal law. And so it's a little bit of a confusing case, and it may not like really strike people as something that's dire. It may not even, register on, people may not even understand the complexities of tribal sovereignty. But I'll just read some basic facts that the case, found. And it basically holds, it's making an argument based on the 10th Amendment. And the 10th Amendment, it's a really, like many things written in the past, it's really poorly worded. It's hard to understand. But more recently, the right wing has been using the 10th Amendment to say that if the federal government does not explain its powers, then states basically assume jurisdiction. And in this case, Brett Kavanaugh was citing the 10th Amendment and saying, since the United States hasn't successfully, written legislation, therefore the state of Oklahoma and all states, not just Oklahoma, all states with certain exceptions, have supreme sovereignty over Indian country or Indian reservations that fall within its territory. And the case that, Castro Huerta was making and bringing forward to the court was saying, actually, according to the Major Crimes Act, which was a piece of legislation that was passed in the late 19th century that made Indian reservations, federally recognized Indian reservations, the sole jurisdiction of, or almost the sole jurisdiction of the federal government when it came to criminal law. And so why this is important is because Brett Kavanaugh is reading these very broad powers of state sovereignties over native nations. And to put that into historical context, the basis of federal Indian law comes from 3 court decisions known as the Marshall Trilogy, which happened in the early 19th century. And it was when the Supreme Court was really adjudicating in the absence of congressional laws guaranteeing that, the federal government would uphold its treaty rights, as well as basic protections for Native people who were not citizens of the United States, and basically protecting them from the overreach of states. And so the state of Georgia was trying to remove the Cherokee Nation and the so-called 5 civilized tribes from its state boundaries. And doing so with extreme violence and force actually resulted in the removal of thousands of people, a quarter of whom died on what was known as the Trail of Tears, right, thus bringing them to Indian Territory, which later became the state of Oklahoma. But these court cases basically determined that states do not have jurisdiction over these distinct semi-sovereign, or what the court ruled as domestic dependent nations of people, and that there should be a separation of powers when it comes to that. And this isn't an old battle. This is something that has been fueled by white supremacists in the 20th century following World War II. There was a big push to finalize finally get out of the Indian business. And so Western congressmen and senators from Western states, such as Arthur V. Watkins, who was from the state of Utah, began advocating for what they called a program of termination, which would essentially liquidate federally recognized tribes and their land base and open them up for privatization. There's been, I'm skipping a lot of history. There were schemes of privatization and allotment and dispossession that happened in the 19th century, of course, but there was a lot that happened in the 20th century. And these termination policies began with, the vanguard of those termination policies always began with state criminal jurisdiction. And there was several cases that were decided. There was a lot of resistance on behalf of Native people. My people, the Yocheti Shakoi, or the Lakota or Sioux nations in South Dakota, actually organized this massive Get Out to Vote campaign to protest Public Law 280 in the 1950s and the 1960s. There was 90% voter turnout on the reservations for a state referendum. It was the highest voter turnout that we've ever had, and it was essentially to vote against Public Law 280, which would implement state jurisdiction over tribal lands. And this was a final attempt by states like South Dakota and other Western states to essentially make headway into our territory. And it did disestablish and it did terminate tribes such as the Menominee, nation. If your listeners are interested, you should all look up this wonderful activist. Her name is Ada Deer. She became the head of the Bureau of Indian Affairs and helped reestablish her nation, the Menominee Nation, which is mostly in Wisconsin. They were disestablished, and their lands were opened up for privatization, specifically destroying and liquidating their lucrative timber industry. And there was also cases, that led to the Red Power movement in the Northwest with the Fishins, when you had white fishers in places like the state of Washington pushing against tribal sovereignty over salmon runs. And basically organizing these really racist and violent campaigns called, Spear a Squaw, Save a Salmon. And they were creating what were called treaty beer, which was like beer that was used to fundraise against or for states' rights and what they called equal protection. So you had all these groups, these right-wing, overtly, in some cases, white supremacist organizations that were making this argument that it was unfair that what they perceived as a racial group of people, i.e. native people, native nations with political sovereignty, had special rights over whites. And so they were using the language of the Emancipation Proclamation. They were using the language of civil rights in terms of advocating what they believed for or against reverse discrimination. And why this is important for this moment in time is that this case decided who has criminal jurisdiction over a non-native, and in this case, a non-citizen, committing a crime, a violent crime against a native citizen of the Cherokee Nation. And in the past, usually when there's a crime committed by a non-native against a non-native on Indian land, the state does have jurisdiction, and so too does the federal government. So this idea that concurrent jurisdiction is somehow a moot point or something to be debated doesn't really follow court precedent, because that has already been in place. And in this case, this is basically implementing and taking state law or state jurisdiction and forcing it onto the Cherokee Nation or onto tribal reservations writ large, who don't have necessarily concurrent jurisdiction with states. And there was a recent legislation that was passed, the Reauthorization of the Violence Against Women Act, that has given tribes more power in prosecuting non-Indians for crimes against Indians on reservation lands, and that actually includes things like child abuse. So this is a larger question of sovereignty. And the next case that's coming on the Supreme Court docket next year is Brackeen v. Holland, which is a case that's trying to gut and formally overturn the Indian Child Welfare Act. And they're using the same 10th Amendment argument here. So there's a lot to be worried about. And there's a lot of historical context kind of informing both the decision of the majority of the court, the right-wing judges, as well as the dissenting opinions.
And I know, just to the layman, maybe I'm misunderstanding this, but in the opinion, Kavanaugh, who wrote the majority opinion, says Indian country is part of the state, not separate from the state. As a matter of state sovereignty, a state has jurisdiction over all of its territory, including Indian country. Unless I'm missing something, doesn't this make most treaties null and void? I mean, we're talking about complicated things, jurisdiction, et cetera, but aren't treaties meant so that the state does not have jurisdiction, criminal or otherwise, over native land?
Yeah, and that's the big question here. It was explicitly stated, by the so-called founding fathers of this country, that Indian nations couldn't enter into formal relationships with states because states weren't sovereign. And in fact, New York State tried to enter into these kind of really dubious treaties with some of the Haudenosaunee Confederacy, which the federal government kind of clamped down on, saying, this is the war and diplomacy are the sole dominion of the federal government, and these are separate, distinct nations. States have no power. It would be like California making an agreement with Russia. It makes no sense. It's overstepping the boundaries according to the Constitution. If you believe in that, apparently some of these justices don't. That they have the authority to go above and beyond what is delegated to them in terms of powers and sovereignty of the states. And again, it goes back to this larger question. Even if you believe in states' rights, like if you go back to, I don't know where your listeners are listening from, but look at your state's constitution. And if you're listening from a Western state and you live in a Western state, more often than not, your state, as part of its constitution, within the first part of it, often after the preamble, they have an acknowledgement within the Enabling Act, which was a congressional act that made that state possible. But in that Enabling Act, it explicitly says that states, especially those in the West, will forego any kind of relationships or jurisdiction over tribal lands. And so this whole idea that somehow, I mean, this is actually in Oklahoma's Enabling Act as well. And so the court has legislated this law out of existence, not only at a federal level, but also at a state level. And so I don't understand how we can, go forward in terms of these arguments about states' rights or federal power when the court has actually misread and is victim of this misinformation campaign that was promoted by the Oklahoma government. How can we go forward with any kind of just relations between states and tribes when the highest court of the land has a fundamental misunderstanding of the very premises of federal Indian law? And I'm the last person that they want to be hearing about this from, because I think that law is based on conquest and there's certain illegitimacy. But that's a question for a different day. And what Castro Huerta was arguing in this case was essentially, and as they were arguing in the 2020 case, in the McGirt decision that found half of Oklahoma is still Indian reservation land, and what even a conservative reactionary judge like Neil Gorsuch, who wrote the dissenting opinion, what they find is a very just conservative reading of the law and saying, actually, you know what, the United States just needs to uphold its law. And this is the premise. That's not radical. That's not revolutionary. It's actually a very conservative reading. But when you don't read the law according to how it's written in practice in real life, then you get these, hallucinatory, conclusions to say that somehow states were just overnight granted authority, nullifying their constitutions, nullifying, legal precedent and congressional law that prohibited them from interfering with the affairs of tribal nations.
Right. And, who am I to say? But to me, I don't think it's a misreading. These folks claim they're the originalists. They just go by the book of the original Constitution. They, if people want to argue that we shouldn't follow, let's talk the Second Amendment. That was when there was muskets. That's a different discussion. But these judges, the conservatives, claim they're originalists and they're just going, to the letter of the original Constitution. But like you said, the original Constitution does not allow for this. It states the opposite.
Exactly. And that's why you get somebody like Gorsuch, who considers himself a textualist, as what I think is what they call them. But he's a minority amongst them. And this is not about, like you said, this is not about returning to the original intent of the Constitution. But in some ways, I think it kind of is. I think there's an argument for both. I would argue that white supremacists and reactionary judges know exactly what they're doing. I mean, there's a reason why somebody like Neil Gorsuch gets put onto that position, gets put onto that court, or somebody like Brett Kavanaugh, who's been accused, have had multiple sexual assault allegations leveled against him. Somebody like Clarence Thomas, who was married to an inside operative in the January 6th, insurgency, or whatever you want to call it, in Capitol. These people are not somehow above the social and political circumstances of this country. In fact, they're very much influenced by it. That's why you can have somebody like Neil Gorsuch, who rules, generally in favor of tribal sovereignty. He was the majority opinion he wrote the majority opinion on McGirt, which is, I think a lot of people were kind of like fawning over him. The liberal press was fawning over him for doing this in certain quarters that understood what this actually meant. But if you look back at his decision and his views on abortion, they're actually completely backwards, because the overturning of Roe v. Wade, while it affects the broader U.S. Nation and women and people in general, nobody was really talking about how it affected tribal nations. So for example, there's multiple instances of things like the Violence Against Women Act. Why do we need a law that protects Native women? Well, if you go back and look at violence against women, the vast majority of violence against Native women is perpetrated by non-Native people who often escape justice because of these very, kind of murky jurisdictional quagmires of tribal, state, and federal jurisdiction. And perpetrators know how to circumvent those laws. And in fact, many of the studies of rape and sexual assault against Native women came from the state of Oklahoma because there is such a fractionated land base. Well, also you have something that's called the Hyde Amendment, which forbade federal funding for abortion services. The vast majority of reservation-based Native people get their health services from IHS. So even if we wanted to build abortion clinics on our homelands, we couldn't. It is actually against the law. So when Native women and Native people were seeking abortion or reproductive services, they had to go into state jurisdiction. They were already subjected to these and oftentimes, in places like South Dakota, there were backwards anti-abortion legislation at a state level that had been passed. And so this whole idea that Neil Gorsuch or the Supreme Court in general can parse out what tribal sovereignty is on one hand, but then disenfranchise more than half of a population of their guaranteed basic, not just treaty rights and rights to healthcare, but just their basic human rights to reproductive care. They can do that willy-nilly, and those two conversations, tribal sovereignty and reproductive rights, can somehow be separated, or that the idea that somehow the violence that's perpetrated against Native women has no bearing whatsoever in the Roe v. Wade decision, or even in the overturning of this decision against criminal jurisdiction over non-Native people. It's setting a very, very dangerous precedent, not only for white people, Black people, but also for Native people who've been dealing with the kind of tyranny of state sovereignty since the founding of this country.
And this isn't even really that much of a hypothetical. I mean, just 6 years ago, you were at Standing Rock, I was at Standing Rock. There were a ton of threats constantly from hostile kind of white supremacist North Dakotans who could have came down to the hotel casino, could have came down to the Osheti-Sokolan camp, committed violence, maybe killed someone. Fortunately, that didn't happen. The police certainly tried. But unless I'm misunderstanding it, according to the Supreme Court ruling, if that happened, if a non-Native came down to one of these demonstrations and killed somebody, the state of North Dakota would have been the one to prosecute it. And we know that the state of North Dakota, in the case of Standing Rock, was not particularly interested in fair trials. So do I have that right, that if this scenario played out in environmental protest, indigenous protest, and a non-Native came and killed someone, that it would not be the sovereign tribal leaders prosecuting that case?
Yeah, there's two things. There's one is even George Washington understood this. He said, how can you put a Native person, how can you give them a jury of their peers when we're invading their land? So he even understood that you had to have some kind of federal oversight to protect Native people, specifically against the violence of white settlers. And in the case of North Dakota, the oil that's actually flowing through the Dakota Access Pipeline is coming from the three affiliated tribes, or the Fort Berthold Reservation, where you have this patchwork jurisdiction because of over a century of allotment. You have multiple jurisdictions overlapping. You have federal, tribal, state, and a lot of these oil workers come in. The gas boom that was happening, the oil and gas boom that was happening through the fracking revolution, brought a lot of outside non-Native people onto or near the reservation, where there were these horrific, instances in which people were being, women, specifically women and children, were being targeted for sex trafficking and abuse. But because of the patchwork of jurisdiction, it was hard to find where exactly the crime committed and who had authority, and oftentimes state jurisdiction was less likely to prosecute or pursue charges against non-Native perpetrators committing crimes against Native victims. And even in this dissenting opinion, Gorsuch actually points that out, that and in fact, state courts are actually more lenient and oftentimes don't pursue charges. He cited a study in there. And so that's the reason why they had to pass something like the Violence Against Women Act, to just guarantee basic rights of prosecution and jurisdiction over non-native perpetrators. It would be like, I'm trying to think of an instance, it'd be like an Italian, coming to the United States and killing a U.S. citizen, and then saying, "Oh, I have immunity. I'll just go be prosecuted in Italy for this crime." That's really what's happening here at the basic level. But I think it's important to understand that these tensions and these kind of quagmires are the intentional result of the withering away of native sovereignty at the court level. Since we don't have strong congressional action and legislation guaranteeing and spelling out, basic tribal rights to tribal sovereignty, we often get our rights legislated in the court of the conquerors. And there's always going to be an unlimited amount of limitations that they're going to place on tribal sovereignty. The courts have never expanded our rights. They've only taken them away.
Right. And kind of where does this go from here? Because it seems that it's beyond a slippery slope. I mean, they just reversed something that was settled 3 years ago in the Supreme Court. So, I mean, could this potentially get even more broad if other challenges come from, other states like Oklahoma did?
Yeah, I think what people are really paying attention to is the Brackeen v. Holland case, which is, there's a white or non-native adoptive parents who are trying to adopt a native child and say that they were unfairly discriminated against by this federal law that protects native children from being adopted out into non-native homes. It's a historic phenomenon. It's actually a part and parcel of, this whole genocidal practice of boarding schools and Indian child removal. And so this case is really important because lower courts have struck down aspects of the Indian Child Welfare Act, which was meant to reverse, over a century of Indian child removal practices. And one of the core tenets of the argument for Brackeen, for the lawyers who are representing Brackeen, is that the states should have final say. They're making a 10th Amendment argument, and I brought this up earlier, but they're saying that the states should have the final say over adoptive and foster care practices over native children, not tribal nations and not the federal government. And so this decision that was written by Brett Kavanaugh mentions the 10th Amendment twice. And I think that this is setting a precedent for that decision. I think it's important to also look at history and how tribal nations have responded to termination. It's actually had a unifying effect. I mean, this is what led to the Red Power movement that began in the 1960s, was a reaction to federal termination policies and the imposition of state sovereignty on tribal nations and tribal reservations. And it unified Indian country around the question of sovereignty. I'm not saying that that's going to happen in this case, but if we look at history as an example, it's the one thing that has unified, both kind of the grassroots social movements within indigenous communities and our tribal nations themselves. And so I think this is a shot across the bow. There's a lot at stake here. I mean, we can't even get legislation passed within Congress. They're having a hard time even getting funding to do the investigation for the boarding school investigation project that is being directed by the Department of Interior. So this is a very, very dire situation. Unfortunately, Native people don't make up a broad sector of society or have concentrations within key swing districts where our vote would actually matter. I mean, there's some arguments that the Native vote helps swing Arizona. But I think a lot of people are realizing that voting hasn't really, we have a Democratic Congress, we have Democratic executive, But voting won't stop these institutions from stripping away our rights, no matter who's in charge. And so I think we actually there's I think a growing momentum that a more I'm not going to say radical, but a generative solution legislatively needs to happen in terms of protecting protecting native rights. And actually, Neil Gorsuch actually wrote legislation. He wrote the language of legislation in his dissenting opinion to basically spell out just basic guarantees. Which we might see, we might see that, but I think beyond that, it doesn't get rid of the rights, the white supremacist tendencies of these of these federal judges, and it doesn't matter if they're liberal or conservative. Ruth Bader Ginsburg, and even Justice Breyer, wrote majority opinions or wrote bad opinions, basically admonishing and trying to take down tribal sovereignty. So it's not a left. I mean, it is a left or right issue, but it's not a liberal or conservative, Democrat or Republican issue for us. It's a question about colonialism, and that's the question that's looming large for a lot of people. It's like this country can address racism, can address these things, but then we see all of those things be clawed back, even under a liberal president. So we have to be, I think, a lot more clear-sighted about what is possible with elected officials, and understand that tribal nations themselves do play an important role. I mean, obviously, indigenous-led movements in the last decade are challenging a quarter of carbon emissions from both Canada and the United States. There's a reason why they're trying to strip away and do away with our rights, whether it's Brackeen or whether it's this recent decision, Oklahoma v. Castro Huerta. There's a concerted effort to fundamentally undermine and destroy tribal sovereignty because of the impact that it has had in terms of, hitting the pocketbooks of these big energy, corporations. So I think we're living in a time of backlash, but I think we need to be very future oriented in how we are setting up this long game, because we got to this point because of concerted efforts on behalf of the so-called 10th Amendmenters or the states' rights advocates. They have been playing the long game against tribal sovereignty, and tribal sovereignty has also been playing the long game against them.
Absolutely. Thanks so much for explaining this. And, I think it's very important because, frankly, a lot of times when the discussion goes to white supremacy, the media covers it more towards Black and brown people and forget kind of the original sin of this country. Thanks, Nick Estes, host of the Red Nation podcast and author of Our History is the Future, Standing Rock, First the Dakota Access Pipeline. Let's stay in touch.
All right. Thanks so much, Jordan.
Thanks for watching, and make sure to tune in to Status Coup's daily live stream Monday through Thursday at 5 o'clock Eastern Time and Fridays at 4 o'clock Eastern Time.